Welcome to Law for Life with Georgia.
Hey everyone, welcome into an all-new episode of Law for Life with Georgia Konstantakis. I am your host, Mike Leon. Georgia here brings nearly 3 decades of Wisconsin legal experience to help her community stay informed, protected, and prepared for whatever life brings. And in today's episode, Georgia's going to explain how real estate fits into your estate plan, what happens to the property after someone passes away, and how to keep it protected for that next generation. Georgia, it's good to see you as always. I'm interested to talk about this topic because I know a lot of families out there probably see their home as more than just an investment. Why does it deserve its own conversation when people start putting together this estate plan?
Oh, well, thanks, Mike, for having me. Appreciate you having me here. So estate planning is by far one of the most critical steps. A lot of people avoid it. They don't want to deal with it. The concept is, I'm never going to die, right? But that is not the reality of things, right? We're all going to go. We're all going to die. Death and taxes, 2 things we can't avoid. So one thing that I do for clients is, in order to avoid probate, what we do is we take that real estate and we put that real estate into a revocable trust. And sometimes we would do an irrevocable trust depending on the client's needs. So what I do when I start someone's estate plan, I have them fill out a financial questionnaire form. And that's critical. It's going to show me what assets this individual has. And not everybody fits into the same estate plan. Everybody has different needs, wants, and the reality is there's different options available to you. So estate planning is critical, especially when you do own real estate, to make sure you're avoiding probate and making sure that the asset gets distributed to those beneficiaries who you want to have the asset. It's critical to make sure that that is one step that you focus and do.
Georgia, let me ask you, some people I'm sure out there think about adding the child's name to the deed, and that could be a potential quick fix. What are some of the risks of doing that without consulting legal advice?
Yeah, so first of all, depending on how old the child is, if the child is under the age of 18, absolutely not. If the child is a little bit older, and more mature, the concept is to give it to them right away, to let them reap the benefits. However, you are not taking advantage of the step up in basis. One thing that people don't understand is the minute that you die, you're able to take that asset and get the value of that asset at the time of death. So for example, say you bought this property for $100,000, just a simple example. Now the property has appreciated in value. It's up to $200,000, right? If you give them that property with a quick claim deed directly to that child, and you just give it to them outright, number one, it's no longer your property. Number two, you have absolutely no control over that asset. And number three, they cannot take advantage of the step up in basis. So what you've done essentially is said, okay, if they turn around tomorrow to try to sell that asset, they're going to have to pay a capital gains tax. Whereas if you waited and had that asset transferred upon death, then they get that step up. That 100,000, now it's worth 200,000, bumps it up to 200,000. So they start at that 200,000 basis. Does that make sense?
Yeah, it makes sense. And I wanted to ask you about the transfer on death deeds that Wisconsin allows. Can you kind of explain that? Because I've never heard that term. Someone out there may listening to this, maybe they've never heard of it. How does that tool work? And when does that tool make sense?
It does make sense if, for example, say you've got a house and you just got a couple of little assets, maybe a couple of bank accounts. Those you could designate beneficiaries and name beneficiaries without having to do a full-on trust. So say you've got a house and, just like I said, that and maybe a couple of cars. The transfer on death deed, what it does is, upon your passing, that property would then inure to the benefit of your children. Your children would get it. But you have to actually record this document at the Register of Deeds. It's not automatic. The document needs to be prepared by a lawyer. There's a real estate transfer return that needs to get done. It's not automatic. So one of the things that I like to say to my clients is, depending on where you fall on the financial chart, we make a determination whether we're going to do what we call is a 5-pack. So what we do is we'll have a will, a power of attorney for healthcare, a power of attorney for finances, a living will, and a HIPAA release. We call that a 5-pack. And what we do is we'll offer the 5-pack along with the transfer on death deed. So you're avoiding probate. The asset now jumps and goes directly into your children's names upon your passing. And it's a beautiful way to handle real estate if, number one, you trust that these kids are going to do the right thing. Sometimes when you've got multiple children listed on a transfer on death deed, there are fights. And maybe one of them wants to sell, two of them don't want to sell, one wants to buy out the other two. There are so many variables that could happen in a situation like that I try to, make sure that the clients are aware that there could be potential arguments between the kids who get the asset. So 9 times out of 10, just sell it. Proceeds get split between 3 kids or 4 kids or however many kids you got.
Georgia, what if the home's owned by a trust? How does that change the way it's handled when someone passes?
So if a home is owned by the trust, the trustee who has the successor trustee now, because the person has passed away that owned the property, the successor trustee at that point would initiate, and they control. The good thing about having a trust, you just got one person who's in command. And that person decides, we're going to sell this house. And the beneficiaries technically have no say-so. That successor trustee decides. And the ball is in their court, whether they're going to sell the house or whether they're going to transfer the home into the 3, I'm using 3 children as an example, but using these, putting it into those 3 children's name,
Yeah.
It really just depends on, what the beneficiaries obviously want. We're not going to have a bully successor trustee, but at the same time, if there's infighting between those beneficiaries, the successor trustee is the one who controls anyway.
And speaking of infighting, I know that I'm sure some of the infighting could be caused because there's liens on the property or there's property taxes they know about, mortgages. How does that come into play with respect to all this, especially during whether it be the probate process or the trust administration process?
Yes. So anytime there's any types of liens on the property, whether it be a mortgage or a mechanic's lien, say there was some work done and the contractor never got paid, or say unpaid taxes. In that situation, if you've drafted a good trust, you have that language, payment of debts, taxes, and expenses get paid off the top before any distributions are made. So the first thing that gets taken care of is the mortgage, making sure that the mortgage is paid, making sure that the taxes are paid. And the successor trustee has those responsibilities upon the decedent passing away. That successor trustee is in charge of making sure that they've upkept that property so that it doesn't get run down. I actually had a scenario where, unfortunately, a trust could not be located. The house actually was damaged by a flood. And unfortunately, it depreciated in value significantly because the pipes burst and then there was water everywhere. It was flooded. So it was a nasty situation and had to be mitigated. And unfortunately, the decedent who passed away, didn't have any direct decedents, meaning there were no kids, no husband, no living husband. Everyone was gone. So it was going into that second generation of individuals such as brothers, sisters, and nieces and nephews. So, everybody's busy, everybody's got lives, but if you do have a situation like that, somebody's got to take control. And that's exactly what happened in this case. One of the beneficiaries stepped up and took control.
Speaking of take control, what about clients who have multiple properties, vacation homes, rentals, and things like that? What are some extra steps you would advise them that they should take to help keep things organized and stay out of probate?
Sure. So one of the things that we do is we advise clients who do own real estate that if it is a rental, sometimes there's exposure to the rest of your assets. So we do advise them to either put it in an LLC of some sort to protect the asset. And if that's the case, then what we do is we have the shares, whether it's member interest, in this case it would be member interest, the LLC, those member interests then would go to the beneficiaries upon that individual passing. So we create and draft documents that will allow the next of kin to step into the shoes of the decedent and then continue to operate that LLC. So that's what we do for rental properties as well as Airbnbs. It's really important to make sure that those assets are in an LLC to protect it from liability. Someone slips and falls, someone hurts themselves, say someone dies in your house, and you were negligent, you didn't do something you were supposed to, whether it's cleaning the snow, something of that nature. And sometimes insurance doesn't cover that amount. I'd say to all my rental clients and my Airbnb clients, make sure that you've got a policy as well as a normal policy as well as the umbrella policy. There's two separate policies that you should have. It's critical to have both of those and have a huge enough umbrella policy to cover those incidental situations. You don't want to expose yourself. So, and a lot of my clients will say, well, I still have a mortgage on this property. Usually mortgage companies are pretty good about allowing you to put that asset in an LLC after it's been purchased. And then it's just a protected asset. So long as the individuals who are the owners are the same people who bought that asset at the original stage of financing. So that's for rental properties. Now, for primary residence, we always say take that asset, put it into the trust, protect it from probate, protect it from We've got a lot of provisions in our trusts that protect the beneficiaries even from themselves. One of our clauses is an AODA clause, and it protects against individuals who have a gambling problem, individuals who have an alcohol problem, or maybe they join a member, a cult of some sort. In those situations, we do have added protections. We also have a spendthrift clause in our trust agreements, which protects against individuals who tend to be really bad with money. They spend it foolishly. So we have protections in place for that. We have protections against creditors, individuals who are trying to collect on a debt. Maybe you've got a beneficiary who has a gambling problem and they owe money to one of the casinos, or they owe money to a loan shark. There's all kinds of scenarios where that will pop up, but that asset is protected when it's in that trust. And that's the beauty of having a trust. There's a lot of protections in place. The other big one is it protects against spouses. If it's an inherited asset in the state of Wisconsin, it's off the table. So if that individual, say one of your kids is getting a divorce, that asset, because it's in this trust, it's an inherited asset. It would not be part of your divorce proceedings. So it wouldn't be part of the whole marital property portion of the divorce. So,
Georgia, as we're wrapping on today's episode, for people listening and they own a home, let's say, but they haven't updated their plan in years, what's one thing that they should check right now to make sure that the house is protected?
Well, first and foremost, I've seen clients who, especially in blended families, you have a situation where if you don't do anything and you don't plan, you don't have an estate plan in place, and this is honestly a true story. I have a client who this did happen to. She thought she was on the title. She thought it was husband and wife on the title, and that wasn't the case. She paid down the loan, completely paid off the mortgage, and then found out after the fact that she was not even listed on the title. Number one, pull that title, see how it's titled. Make sure that you're listed on there, especially in a blended family situation. So right now, guess what? 50% of that house and that hard-earned money, she paid off the mortgage, she did everything right, but she didn't check the title. Now she has to share that house with the decedent's two children from a different relationship. So it's a nightmare situation. Always check the title. That's number one. Number two, see me. I can help you get your assets all in order, get all your affairs in order, make sure that your estate plan is what you want and not what the court is dictating.
Georgia, thank you so much for the time and insights on this topic. I truly appreciate it, as always.
Thanks, Mike. Thanks for having me. I appreciate you.
And that wraps up today's episode of Law for Life with Georgia. If you want to learn more about Georgia and the team over at Konstantakis and Konstantakis Law Office LLC, do me a favor, visit konstantakislaw.com today. Thank you for joining us. But before you go, don't forget to like, subscribe, leave a review and comment, or share the episode with someone who needs to hear it. As always, I'm Mike Leon. See everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.